Hi, and welcome back to the show. I'm attorney James Betzold, and this is the Prima.Law podcast. This is a show where we interview real attorneys who have handled real cases and have made a real difference in the lives of their clients. We've recently been focusing on federal court litigation because we are immigration attorneys. I'm an immigration attorney. And we've been recognizing that over the last number of years, there have been agency delays or unfavorable decisions that are unprecedented coming out of USCIS, DHS, and the Attorney General's office. So it's become more important to be able to take these cases to federal court when possible. Our guest today is attorney Bradley Jenkins. He works for Clinic. You can find information about them at cliniclegal.org. That is the Catholic Legal Immigration Network, and they've been providing trainings, literature, and a lot of important materials for teaching immigration lawyers how to be better and even how to deal with some of these federal court issues that arise. I can say personally, early on in my practice, the favorite book I had in my arsenal for dealing with immigration court was titled Representing Clients in Immigration Court, published by Clinic, and I'm eternally grateful for them for their efforts in publishing that book because I used it every day, still use it to this day. It's a very helpful resource. As always, the show today is brought to you by Prima.Law. So Prima.Law is immigration software for immigration practitioners. We use it for autofilling our immigration forms, for doing our case management, so managing the tasks and all the different things we need to do, collecting documents, sending out checklists, managing questionnaires that need to go to the client that they can fill out online. And now our new and improved, well, it's not new. We've had it in the lab section for a while, but our severely improved package assembly feature, which now lets you assemble all of your forms, all of your addendums, all of your supplemental exhibits. You put that into one PDF. You can create a very customizable table of contents, index. It inserts in exhibit sheets automatically. It'll paginate everything, so you've got your Bates numbers on the bottom of each page, and it puts the pagination in your table of contents as well. Extremely useful when dealing with cases in EOIR or with USCIS. Find more information and a free trial at www.primafashinow.com. Also, Prima.Law. You can find us there as well. All right. Thanks for sticking with us and enjoy the show. All right. Welcome back to the show. This is the Prima.Law podcast, and we are joined today by attorney Bradley Jenkins, who is the federal litigation attorney for Clinic, the Catholic Legal Immigration Network. You can find more information about them at cliniclegal.org. Attorney Jenkins has been involved and lead counsel on a number of important cases for immigration, including that one case that maybe you've heard about already, LMM v. Cuccinelli, where a federal court agreed that Ken Cuccinelli, the acting principal person in charge, who's the most deputy supreme director of USCIS, was actually illegally appointed. And so some of the regulations he had put in place or policy directives were nixed, which is kind of nice. And we'll be excited to hear more about that case. So, Bradley, welcome to the show. Thank you for joining us.
Thanks for having me.
And let's start with your journey to becoming a lawyer. What made you want to become a lawyer?
I started my journey towards the legal profession back in 2007 or so. I had the opportunity to be a Mennonite voluntary service volunteer through the AmeriCorps program with the CARE Coalition here in DC, the Capital Area Immigrants' Rights Coalition. When I was in college, I had done some basic kinds of humanitarian work, but hadn't really given much thought to the law. But then at CARE Coalition, I was able to do the kinds of research and writing that I sort of always enjoyed doing as a professional activity. But then if I did my job well, people got out of jail. People, didn't get deported, and sort of the concrete consequences of doing your job well as a lawyer really appealed to me. And so I did that for 3 years before going to law school. I was a BIA accredited representative actually for a couple of those years. And so actually tried a cat case in front of then Judge Schmidt before I even went to law school. So.
Oh, wow.
Yeah.
That's good for the resume, huh?
So I was hooked pretty early, and then went off to law school sort of further.
Tell us a little more about the CARE program, because I'm not very familiar with that.
Sure. CARE Coalition is the nonprofit organization here in the DC area that provides legal services to detained immigrants in removal proceedings, both in Virginia and Maryland. They serve both adults at Farmville and other adult detention facilities, and then there are also some minors who are in ORR custody that are served here. So we would go to the detention. As a legal assistant, I was going to the detention facilities, interviewing prospective clients, helping with the legal orientation program, and they're an organization I continue to support to this day. They really helped me get started.
So you were working with like all types of EOIR, like immigration court cases, for that organization?
Yeah, exactly. In order to do detained work, very frequently you have to imagine the entire organization from the ground up to cater to the obstacles in doing detained work. So we were doing exclusively that for the.
So you were able to handle things. Would you do like asylum, cancellation of removal, bond hearings, things like that?
Exactly. Yeah. And I started just doing, sort of just doing the intakes and presenting them at our intake reviews. I sort of sometimes joke that the first practice at oral argument that I had was just persuading the legal director, right?
That the case you should be taking.
I believe in this case, and if they told me that they didn't have relief, I went back and did more research and advocated for this person based on as I was trying to learn the law. So I have a lot of fond memories of working at CARE Coalition.
So that's something you did after your undergrad?
Yeah, from 2007 to 2010, I was there as a legal assistant.
Wow. And so during your stint there, you became a BIA accredited representative as well?
Mm-hmm. Yep.
Oh, that's really cool.
Yeah. I'm fond of the recognition and accreditation program as well. The accredited reps, clinic affiliates actually comprise a lot of we help a lot of people become accredited representatives. Mm-hmm. I have a lot of fondness for the sort of tenacity and sort of initiative of folks who want to serve the community in that way.
Yeah, and it's like super important because, like for a private attorney to handle certain cases, I mean, there's certain cases we just don't take. There's certain cases where for most individuals or many individuals who are on the docket, they can't afford it, mostly because they're detained.
Right.
And can't work and maybe don't have the support system outside. No, that's fantastic. So yeah, for anyone who doesn't know, when you're able to get into the jails or the detention centers and interview people, screen them for relief, you get really well versed in all the nuts and bolts of the immigration court system. And you can sort of start to see, oh yeah, this is a good case. And this is a challenging case. And the law is against us on this one. So that's fantastic that you're able to get all that experience even before law school, before entering, before getting your law degree.
Yeah.
All right. So after working at CARE, how was the transition to clinic? Like, how'd you find out about it?
CARE Coalition was actually one of the folks who helped with the BIA Pro Bono project, which was a project to find pro bono representation for vulnerable immigrants who had a pro se appeals pending with the Board of Immigration Appeals. And at the time, and when I managed the project, one of the things we were able to do is have volunteer screeners go down to the board to screen cases, and the legal director at Care Coalition was one of the screeners. And so I was sort of familiar with the BIA Pro Bono project. I'd also heard of clinics training programs, and had been to some clinic trainings as a paralegal. And so as I was graduating from law school, I saw that they needed a new coordinator for the BIA Pro Bono project, and was just lucky enough to get that job. It was a great first job out of law school. I'm really grateful to Clinic for that opportunity. And for 5 years, I found pro bono attorneys for BIA appeals cases. We stopped about 200 deportations while I was there. So
wow, that's impressive work. That's a heavy caseload too.
I mean, I wasn't doing them all myself by any means. I was mostly finding cases and mentoring pro bono attorneys who we then referred them to. But
sure.
It was, and so the pro bonos are a really important force multiplier for the limited resources we had for the project. But yeah, we're really proud of that project and its ability to. It was, now we more and more see remote representation models that use various forms of televideo and all kinds of things to provide representation to folks from afar. Mm-hmm. The BIA Pro Bono project was really one of the first to say, you know what, you're an attorney in Chicago or New York or wherever, why don't you represent someone on appeal in Harlingen or Eloy or some of these other places where pro bono representation is doubly difficult to find. Mm-hmm. And so we were able to identify really good cases that way and get relief for some folks who deserved it.
Awesome. So then 5 years in that position as the BIA Pro Bono project director?
Manager, director, coordinator.
Okay. And then what brought you from that to federal litigation attorney?
Sure. When this administration came into power, we at Clinic recognized that litigation and also just removal defense type work was going to become all the more important. Sort of many immigration legal services nonprofits focus on more routine kinds of applications on USCIS work. And so we set out an agenda, both that we were going to try and build capacity for folks who wanted to provide more representation in the immigration courts, because we knew that that's one of the places that we were going to have to fight this new deportation agenda, this renewed deportation agenda, and we'll also probably going to need to bring more federal litigation. Before the Trump administration, Clinic was not counsel of record in federal cases beyond sort of ad hoc petitions for review or other cases maybe coming out of the BIA Pro Bono project or something. But starting with this administration, we've had now an organized approach to bringing lawsuits in district court, organizing around federal court appeals in removal proceedings, and so given my appellate experience, I was able to sort of transition into that role.
Yeah, so it was a calculated, planned out recognition that, hey, we're gonna end up in federal court on these things.
Right, and we have the sort of subject matter expertise, but not the litigation program yet. Mm-hmm. So litigation needs to be a priority for Clinic, and so they created the federal litigation attorney position, and that's where I ended up wanting to be.
Awesome. Are there other federal litigation attorneys there, or?
So I'm the only person who focuses solely on federal litigation. I'm part of our Defending Vulnerable Populations project program, and so we have our entire team engages in our federal litigation work. We have several folks, our managing attorney and our director, all do federal litigation work. But like I said, our Defending Vulnerable Populations team also aims to reissue practice advisories on emerging issues of immigration law. We write the Representing Clients in Removal Proceedings manual that's published by ALA.
Yes. Hey, thank you for that book, by the way.
Yes.
So back when I was starting, I think it was my first year of practice when the first version of that book came out. And I think I must have had it like the first month that it came out, because I saw it and I was like, oh, this is awesome. This tells me exactly what I need to do. And I could walk into court without being terrified, because it was hard to find a mentor at the time.
Yeah, and that's a lot of what our what?
Now you're like in the third or fourth version of that book, if I'm not mistaken.
I think it's the fifth edition, or something, fourth or fifth. And so Clinic's Defending Vulnerable Populations program is we're really trying to help people for whom maybe representing vulnerable people in removal proceedings sounds scary. Hopefully Clinic is providing some tools to make that a little bit less scary, both by providing resources to attorneys, but also suing the government when they're trying to make things even more scary. So we're trying to do both and approach.
Yeah, and that's, especially with the federal court stuff, that's a trend that we saw. And unfortunately, a lot of times, just the way the practice is set up, or the way, that our business models are set up it used to be things would be decided in a somewhat reasonable amount of time. So even if it took another month or 2 months or 3 months, it was still, it was just waiting for the result was still going to be faster than filing a federal lawsuit about it, right? And now that's not the case. Well, and it's ridiculous. With some types of cases, it's just they drag their feet and it takes forever. And with other types of cases, at least since the shutdown, we've seen people get their DACAs approved, like the DACA renewals approved in 14 days.
Wow.
And it's not just our firm, it's other people. It's been really quick. And I-130, I just, did a consult with someone yesterday. We were reviewing their file. We had filed it in February, and a couple weeks ago it was approved. We got the approval notice on I-130, which we had been telling people, hey, this could take 6 months to a year because of processing times and whatnot. So there's really no reason that somebody waiting on a U visa waitlist decision should have to wait 54 months if they can do all these other things so quickly right now, and it's when you start seeing those 54-month waiting periods, it's like, okay, we really need to dig in. We need to start taking federal cases. We need to figure out, the cases and how we do it, how we manage it, how it fits into the business model, everything, because it's just the days of the attorneys where they could sit back and say, well, you know what, we just got to wait. And, I'm tired of telling people to wait.
And I would say, so the mandamus style federal litigation, I really encourage folks, if you've never been in federal court before and it sounds like this whole big new scary thing, to think mandamus is often a place where it's a little less big and scary. A reasonable delay is an unreasonable delay once you get to 3, 4, 5 years. There's lots. It's easier to find samples that look like the kinds of problems that you're facing. It's a nice way to sort of learn the nuts and bolts kind of stuff that sometimes the scary part of federal court is not so much I'm bringing a big splashy case challenging Ken Cuccinelli's appointment as the USCIS acting director. But I want to challenge this delay in this case, but it still seems scary to figure out service of process and to get admitted in your district court. And there's these other sort of more nuts and bolts things. And I think the second case I ever filed was a mandamus case, right? Yeah. Just because I was still learning, and it was a nice more reasonable chunk to bite off in terms of learn the rhythms of federal court.
Yeah. So walk us through because you mentioned the big flashy case, LMMP Cuccinelli, which when it came out, I was so happy. It was so nice to see that. Just walk us through it. So tell us how this case began. Tell us about, for example, like the plaintiff, what was happening in the case.
Sure. So the actual policy, if we're talking about the plaintiffs, that was being challenged is that USCIS, through its purported acting director, signed off on a bunch of policies relating to the credible fear process. Prior to this policy change, you had 48 or 72 hours after you were detained to sort of get rest and get your head together before there was a mandatory waiting period before you had your actual credible fear interview, which determined the entire future of your asylum case. This new policy decreased that 48 or 72 hour waiting period to 24 hours. They also changed their policy about continuances from basically a good cause policy to sort of called it you literally have to be in the hospital or you're not getting a continuance policy. It was no longer good cause to continue your credible fear interview, that I've only been in this facility for 24 hours and I'm looking for an attorney, right? We're going forward, right? So that they really tightened the language around requests to reschedule. And so we thought and continue to think that those policies themselves were substantively unlawful, but they were also promulgated by Mr. Ken Cuccinelli, who was unlawfully appointed as the acting director of USCIS. Basically what happened. Yeah, go ahead.
Yeah, just let me ask, because as I was reviewing the case and outcome and everything, I was wondering, and especially, like I told you before, I'm listening to John Bolton's book, right? The Room Where It Happened. And he talks about immigration policy and sort of the chaos in the administration, people leaving, people, sniping at each other, trying to get other people kicked out, putting those seeds in the president's ear, trying to get him to be dissatisfied with others. And it occurred to me, like, who was paying attention to the appointment procedure for Ken Cuccinelli? How did that show up on your radar? Because for me, I hear it as, yeah, so-and-so's appointed as, okay, it's like, whatever, the government's far away, it's over there. How did that show up on your guys' radar?
A couple of things, I think. I mean, part of it was just this sort of repeated, right? We kept hearing acting so-and-so and acting so-and-so and acting so-and-so. And so it just sort of begs the question, like, we were starting to see, and so beyond just the unlawfulness of it, it really seemed to be an abuse of the appointments process, right? We all learned in law school about the appointments clause and how officers of the United States need to be nominated and confirmed by the Senate. And more we've sort of had permanent government by acting officials under this administration. And Trump was even saying things like, I like actings, sort of in response to questions about why these officials weren't going to be going through the advice and consent process. And so we partnered in that case with Democracy Forward, who were really great experts on the Federal Vacancies Reform Act, by which Congress allows acting officials to exercise the functions and duties of offices of the United States, but it does regulate the circumstances under which officials can act. And so ultimately the LMM case, its holding is that Ken Cuccinelli's attempt to promulgate policy without being validly appointed as the acting director of USCIS violated the Federal Vacancies Reform Act. Basically, the idea of the Federal Vacancies Reform Act is that when somebody leaves a post, their first assistant, their immediate subordinate, becomes the acting director. And that's exactly what happened when Lee Sisna resigned. Mark Kumans, the deputy director of USCIS, became the acting director of USCIS. And then days later, acting secretary of Homeland Security created a position that was scheduled to disappear once there was a Senate-confirmed director, and then hired Mr. Cuccinelli to fill that principal deputy director of the USCIS position. Long story short, I think the district court got it right when it noted the person who's the automatic acting director is the first assistant, and Mr. Cuccinelli was never designed to be an assistant to anybody. And so that's the sort of short version of why it violated the law. Is he wasn't?
Yeah.
He was being hired as the acting, not hired as the assistant, the first assistant.
Yeah. So they made a special position for him. Didn't exist before. Is scheduled to go away when somebody else gets appointed. I mean, essentially what they're doing is they're usurping the what's it? Not the pecking order. It's the hierarchy. I guess the hierarchy. That's not a popular word. The succession, the line of succession.
Yes, they manipulated the succession order, designation of succession, in order to install him in a way that was a clear end run around the way in which Congress had intended for.
Yeah, and it's not like there was any legal authority that allowed them to just create this and allowed them to go in and do that. I really like where the court also concludes that Cuccinelli was not lawfully appointed to serve as the acting director of USCIS, and that accordingly, the reduced time to consult and prohibition on extensions directive must be set aside as ultra vires under the FVRA and the APA. That's got to be this music to your ears, right?
Oh, yeah. I remember in federal court, we get notices of docket activity in the email, and it was a Sunday morning, actually, when the decision came down.
Oh, really?
Yeah. And so I remember checking my email on a whim, and it was I think Judge Moss did a really great job of explaining why the government had broken the law.
So were these the only policy directives that Ken Cuccinelli had put forward?
No, and we've seen other folks be putting FVRA claims into other cases. We'll see how that played out. But there was a pretty extended period of time during which he was the acting director, and obviously he was acting as if he were the acting director, I should say. And I think it's certainly worth scrutiny, any of the actions he took during that period. Yeah, that's the danger of playing fast and loose with the FVRA, right? Is it's the FVRA. Congress gave pretty strong medicine for violations, and Congress has its constitutional role to play in confirming. Hopefully,
so the FVRA contains the medicine in there. It contains the remedy.
Right. The FVRA expressly provides that, and the actions of a person that don't comply, whose hiring doesn't comply with the FVRA, shall have no force or effect. Right. So just as if you or I could say on this podcast that it is USCIS policy that everybody gets asylum. But it doesn't become the policy of the United States because we're not validly appointed to be that decision maker. And so that's what Congress basically said in the FVRA is you're no better than a man on the street if you're not imbued by the power of the government by this law.
So he's still, I just looked it up right now. His official title is Senior Official Performing the Duties of the Director. USCIS or United States Citizenship and Immigration Services Director vacant. So he's still there. Is there any other remedy for his like straight up removal from the position, or is it just everything he does we can challenge based on the FVRA now?
Right. He still may well be a validly hired generalized government employee or advisor to the secretary. That may be more difficult to challenge. But if to the extent that someone who is an officer of the United States and is exercising the powers of an office that needed to have gone through advice and consent, that's when there's a problem.
Okay. Well, definitely a great case. I think that gives some options to everyone because he's still there. He still looks like he's still enacting policy. And I'd be surprised if it were somehow policy that's good for immigrants or lawyers in that matter. Okay, well, let's move on to another one of your cases. Let's go back to matter of LEA.
That's right.
So when I have cited this case in the past and used it in court to try and convince the immigration judge that yes, this is a valid particular social group in an asylum case, this was one of the cases that we would use, saying, look, family is the quintessential social group. But then it was Attorney General Barr, was it him who stepped in?
It was acting Attorney General Whitaker and then Barr who decided the AG version of matter of LEA last year. And when Attorney General Whitaker issued that notice saying we're going to take a look at the circumstances under which families are particular social groups. That's when Clinic had appeared as an amicus in the prior BIA case, but Clinic then partnered with Mr. LEA's previously hired immigration attorney and helped to represent Mr. LEA before the Attorney General, and we continue to represent him now. That case was actually remanded to the immigration judge, and so we're preparing now for an individual hearing.
Okay, so for those who are listening who aren't maybe familiar with how badly an immigration court case can go, you can win, and then the government can appeal, and you can win that. I don't think that's what happened in this case, but you could. But then the Attorney General sitting in his office in Washington, D.C. can say, you know what? I don't like it. I don't like it. I'm going to refer it to myself. I'm going to I'll request people to send briefs to me. However, under this administration, it seems like I'm going to request that they can submit briefs if they want, but I've got my mind made up. And then they issue a decision that it can be completely contrary to what the immigration judge decided and what the BIA decided. So,
or what 10 courts of appeals have decided.
Or what courts of appeals have said. Okay, so that was the question I had. I wasn't certain on. So the Attorney General, can he refer, like Sixth Circuit Court of Appeals takes a case, they decided, can he refer that case to himself?
It may have needed to be remanded, or the answer to that is maybe. Although I don't think that's been what's tried. I was more making a glib comment that among the courts of appeals, there has been a broad and long-standing consensus that families are particular social groups, and that consensus was sort of the baby that was thrown out with the bathwater in the Attorney General's 2019 LEA decision.
And I guess
you quoted the Ninth Circuit that the family is the quintessential particular social group, and that idea was given pretty short shrift, we think.
Yeah, well, like you're saying, I think what could happen is you could have a case that goes to like the Circuit Court of Appeals, gets remanded back to the immigration judge, then it goes up to the BIA, and then still anytime after that, the attorney general can step in, right?
There's actually a case now that he's certified to himself, it appears, many, many years after the fact, where he's actually even expressly raising the question, like, how long is too long for me to certify an old case to myself? Which you can see how it's a particularly pernicious practice to sort of go fishing for some case back that you want to make a point out of, and use that as the vehicle to change policy. So,
oh yeah, you could have someone who's a resident or a citizen already. If you can go back as far as you want, they may have citizenship. Attorney General recertifies a case to himself and tries to pull it all away.
We haven't seen that yet, and I think that would pose special problems.
Yeah.
Well,
yeah, maybe we should edit this part out so nobody gets any clever ideas.
Yeah, we've been seeing, bottom line is I think we've been seeing an increased willingness to use the Attorney General certification process to affect immigration policy. And we're just now seeing, I think, the courts of appeals responding to that. I think just today or maybe yesterday, the Seventh Circuit came down and followed the Fourth Circuit in rejecting Attorney General Sessions' decision matter of Castro Tomb, which was the decision by which Sessions and one attempted to take away the practice of administrative closure in the immigration courts as a document management tool. And so, because of the individualized nature of judicial review and removal proceedings, takes a little while for these issues to filter through to the courts. But I do think we're starting to see some judicial pushback against this practice of Attorney General certifying a case to himself with sort of certain ideas in mind.
Rewrite the whole system of law and tradition and stability that even as practitioners we can say, oh yeah, I'm going to meet with you, yeah, your case, here's what it is, it looks pretty good because this is the law, and all of a sudden the next day it changes. It's highly inefficient, especially when a lot of these immigration court hearings are years apart.
And so this actually brings up a good point that I want to get out into the gospel of the immigration bar, is that we've seen change after enormous change in immigration policy effected by the executive branch over the past several years. And if the DACA case means nothing else, right? It was a reaffirmation by the Supreme Court of the idea that when the executive branch changes its policy, it has to take into account the reliance interests of people who have already relied on existing policy, right? So I want to encourage all of the folks out there to be presenting arguments for their long pending cases that all of a sudden got the rug pulled out from under them. So in addition to saying that the new policy is wrong, saying that the new policy cannot be retroactively applied to my client, because my client is in a position where he or she relied on some former version of the policy, now to their detriment. And that the new policy didn't account for my client's reliance interests, so it can't be applied. So I think study of anti-retroactivity principles of administrative law are increasingly relevant in the immigration practitioner tool belt.
Wow.
If I can get sort of nerdy about it.
That is an excellent point, because it happens all the time.
The examples are too numerous to state. And I'll even say, right, just because it's not in the decision doesn't mean it's not being argued. I think one of my frustrations on my first reading of the Attorney General's decision matter of LEA is we set up a big retroactivity argument, right? We argued it very explicitly. It's an entire argument that the agency actually ignored in that case. And so But I think it's an argument that, especially if the case is on a trajectory to eventually make it into federal court in some way, it's a decision I think the judiciary, it's a principle that I think the judiciary is taking quite seriously.
Yeah, that's well pointed out. Yeah, like we're saying, there's someone can have a case. I mean, we've had cases that have gone on for 9 years, and whenever there's a government shutdown, maybe they had their individual hearing scheduled for then, it gets reshuffled and they go right next to a master some months in the future, and then they get rescheduled for an individual years into the future then again. So yeah, and sometimes, I mean, it's pretty rare now in the last few years that the law changes to their favor.
Right.
So it can really pull, like you said, pull the rug out from under your client who is thinking, oh, I can do this. I can get an administrative closure. I can file an I-601A, and then I can go do consular processing. Where now, all of a sudden, nope, no more administrative closure. Take a deportation order now.
Right, and one of the arguments in that scenario, in particular, would be first that Castro-Tum was wrongly decided, as stated by the Fourth and Seventh Circuits. But that argument, because of principles of agency precedent, is going to be rejected. Right? It's a AG decision. I'm an IJ. He's my boss. I've got to follow it. But there's at least some chance that I think the unaddressed issue of retroactivity could be you could actually argue that to an IJ. I think validly. You'd have to concede that the merits argument against Castro-Tum is foreclosed by agency precedent. We're asserting it here only to go to my circuit. But you could say, and there was actually, I can't remember the name of the case off the top of my head, but there's a recent BIA case where the BIA actually says the agency should be doing retroactivity analysis. It said did the retroactivity analysis and you still lose in the case, but so yeah, it's a tool for the tool belt when you had a plan and new policy is what's ruining it.
So matter of LEA right now, because I'm looking at of course, Clinic published a great practice advisory on matter of LEA, dated August 2, 2019. What's the status of LEA right now?
We're still pending an individual hearing, a trial in the immigration court. We both have a can't case to present, and we believe that if the Attorney General is serious about the case-by-case analysis that has to be done in every case regarding whether a particular family is a particular social group, that we should be given that opportunity as well, and we intend to submit evidence in that regard.
Yeah. All right. Let's go on to another one of your accomplishments. There's so many of them. I'm gonna have like case after case here, and it's one actually from the circuit where I practice. Where'd it go? Trujillo Diaz v. Jefferson Beauregard Sessions, the third, not the second. That was somebody else. All right. Okay, I think I'm going to have to edit this out because I can't remember right now what all this one stood for. But I remember I've had to use it. Is this another family membership one?
This is motion to reopen.
Motion to reopen. Right. Okay, so in the practice, in immigration court practice, after someone takes or is ordered removed, has a removal order outstanding against them, there's certain circumstances where the government can, or typically it's a petitioner, the respondent will file a motion to reopen the case, which effectively gets rid of the removal order, right? Does away with it because they reopen it. You're going to relitigate it based typically on some new form of relief that's available to the respondent that wasn't available before for some reason. Am I right with that so far?
Right. The standard for a motion to reopen is that you're presenting evidence that was previously unavailable, that is material to the claim.
So the idea being, it didn't exist, it wasn't available before, so now it's only fair to let you come back to move to reopen the case so we can consider it like it should be considered.
Exactly.
Okay.
And I do want to be clear on this one. I helped some with this case, and certainly our advocacy department at clinic also helped. This was a case in which Governor Kasich even advocated for ICE not to remove the mother in this family, and the good folks at Advocates for Basic Legal Equality, ABLE, in Ohio, were the ones who actually argued Maribel's case, but through our program with our affiliated organizations, we were able to provide some support and mentoring for the federal court part of it. And yeah, it's now an important precedent. Not only did Maribel's case get reopened, but it's now an important precedent. It's one thing to sort of remember about motions to reopen is that they also don't usually happen with a hearing, right? You file a motion, you reduce what the testimony is going to be to an affidavit or a declaration, and you say, here's my previously unavailable and material evidence, please decide my motion. And there's not a hearing to test credibility, et cetera. And so the rule that most courts have come up with is if you're not going to have a hearing to test credibility, you have to accept what's in that declaration is true. And that's the error that the Sixth Circuit found, is that she submitted evidence which the agency was sort of bound in this procedural posture to accept as true, and it didn't accept it as true. It made factual findings that were contrary to the presumptively at this stage credible evidence. And so that's how the case was eventually reopened, right? The motion to reopen stage is just about whether this evidence matters, not the IJ later in reopened proceedings is going to have to determine whether it's credible, et cetera. So,
yeah. So the story, because I remember it now, because I did read this in preparation for today, and I've read the case before. It's just sometimes you read these cases, and what happens to the individual in the case is like so traumatic. But there's multiple cases that are similarly situated. So sometimes they can blend together, at least for me. And if I'm not inappropriately blending it together, I believe. Okay, so this isn't the case. There's a different case where she was like actually removed from the U.S., right? But that's not this.
This case, yeah, she was removed from the United States. She was able to come back.
Right. Yeah. Okay. So yep, there it is. All right. So let's set up the story a little bit, and you correct me, jump in if I'm wrong at any part here. For some reason, I don't know why, she had a removal hearing, and either it was ordered removed. I don't know if it was in absentia, so with her presence, or if it was after a hearing or something like that. But essentially, what happened is some years later, and during this time, she's on order supervision, right, with ICE.
Mm-hmm.
Yeah, so it's not like
this is the age of prosecutorial discretion.
Okay, so prosecutorial discretion. There we go. Not a bad situation, actually. And then, so she files this motion to reopen, saying, "Hey, there's some severe kidnapping of my family members, and the gang who kidnapped them, the cartel who's kidnapped them, are looking for me. And they told my family member, we're going to do bad things to you and your family if we can't get a hold of so-and-so and so-and-so in your family," right? Your kids, right? Because they knew that they had come to the U.S. or something like that. And it's this has happened multiple times with gangs, especially from Mexico and the Northern Triangle, where there's these threats that happen, and it's all very closely related to just being a family member, right? The gang wouldn't have even known about this other person had it not been for a family relationship. And so she submitted evidence, including, I think it was an affidavits, right? That's typically what you do.
Right. And both her testimony about the changed country conditions were sort of distilled down to a declaration. but the good folks at Able were also able to get an expert, which played prominently in the circuit court's decision, sort of saying why, sort of putting in context why these threats meant that she had valid asylum and CAT claims. And it was factual findings that the BIA relied on in deciding the motion that were sort of contrary to those expert findings. That was the ultimate basis for the Sixth Circuit to intervene. That the Sixth Circuit sort of said, you can't come to that conclusion and accept as true what the expert is saying. And on a motion to reopen, you accept as true the new evidence. And then, I mean, the ultimate rationale is about that simple. And so that's so the Sixth Circuit sort of joining this, you accept the evidence as true principle in sort of a appellate procedure way. But yeah, Ms. Trujillo is obviously very sympathetic person whose life was affected as well.
Yeah, and there's a part in the decision here where, I mean, sometimes stuff that comes out of the BIA or it's over and over in multiple cases. The same wording even. The BIA determined that Trujillo Diaz's changed country conditions evidence, quote, does not support her contention that she would specifically be targeted due to her family relationship. When it clearly does, it clearly states that, it clearly alleges that. And there was another part, I don't know if I'm going to find it right now, but it's sort of like where the BIA was just sort of poo-pooing the evidence. Like, oh, yes, it's this purported affidavit that alleges these things. Where, like you're saying, their job is to accept that as true. And then if they need to hold a hearing to figure out if it really is true or whatnot, then, take it from there. Yeah, they called it a generalized fear of harm. But when there's a gang that's as vicious and violent and deadly to your family already, and they're like, we want so-and-so, that's not generalized. That's really flippin' specific. Generalized is, well, I don't want to go to downtown, or I don't want to go to the suburbs of Chicago because it's violent there. That's generalized. Like, there's no specific threat against you.
Yeah, it's difficult to often read agency decisions. That also another favorite is no evidence. Right? It's not that they engage with the evidence and find it lacking. They say there's no evidence that yada yada yada, and that's a frustrating agency decision to read because there's usually very obviously evidence that, and as an appellate practitioner point, that those are. That's a frustration that it actually sounds in a claim. That's an appellate claim that the agency said there was no evidence that, here's the evidence that X, right? And so if they're literally saying no evidence, then an initial response or an instinct should be to show how, if they really think that there's no evidence, that means they weren't giving reasoned consideration to the record, right? So,
and this was even one of those not the decisions, one of the cases where they had it laid out in the, or maybe I was reading a summary of it somewhere, but essentially, she files the motion to reopen. Of course, ICE gets a copy of it. It's just what happens. And then next thing you know, ICE is coming to schedule her for removal, where for, it appears, years, she had been on this, I guess, administrative closure. And now all of a sudden she's a priority for removal because she had the gall to file a motion to reopen and try and actually win her case after these horrific things were going on.
And I don't remember the exact order that went in. So I don't know if it became clear that enforcement was on the horizon and which order that happened in. But certainly, I mean, this was a case where, like I said, the governor of Ohio was saying that this is not a priority. This oughtn't to be a priority for removal.
Yeah, here from the judge's decision, I found it.
The Sixth Circuit that ended up being granted, right?
Yeah.
This was before Hamama and some of the other cases that looked at habeas relief and stays, but it was a difficulty that there's sort of a gap that we're still trying to find ways to litigate, in which the board hadn't ruled on our stay motion or had denied the stay motion, but we couldn't get review of the stay, but had not ruled on the merits of the motion to reopen. And so there was this gap where we couldn't get a judicial stay, but at the same time, the BIA was we couldn't get judicial review of the merits. And so some folks have filed habeas petitions in that situation. We need to also be thinking about filing separate actions in the courts of appeals. But there's a gap there that takes some care to try to navigate. Well, sort of this question of how do you deal with stay practice in motions to reopen? There's otherwise no final order that we can get federal court jurisdiction over. I'm increasingly thinking that we should just argue that file a petition for review of the denial of a stay and see if we can make that work. But
yeah, this was the case I was thinking, where 2 days after she filed her motions, ICE apprehended her outside of her home, scheduled her for removal on April 11th, and on April 10th, the BIA denied her stay of removal, but took no action on her motion to reopen. It seems like there's bad faith through all of that. So then she filed a petition for review of the denial of the stay and an emergency motion to stay removal. This court denied her motion to stay and dismissed the petition for review on April 11th, so the next day. And then 8 days later, she's removed from the country.
Right. I think we need to revisit that second part where if I think there's a good argument that if the appellate courts have jurisdiction over the motion, the ultimately denied motion to reopen, a denial of a motion for stay is similar final agency action that is sufficiently related to the final order of removal to permit jurisdiction. Or what we hadn't learned yet is, but maybe complicated now by third-gisium, is that some people have had success in habeas obtaining judicial stays in those circumstances.
Yeah, because it seems like with habeas, even the judge has a little bit of discretion, at least to get a delay, delay things just long enough for the other court to issue a better decision or a decision at all.
Yeah, for the board to ultimately actually decide the case.
Yeah. All right. Well, quite an exciting amount of cases you've been able to work on and push forward and advance the cause of true justice. I mean, a lot of times, it's fighting a bureaucracy. How do you do that? Okay, let me ask you this: how do you deal with fighting a bureaucracy every single day? How do you manage that?
I'm lucky enough that, part of my tool belt, I guess, is if I get too frustrated with the bureaucracy, I know how to sue them. It is, I think my early, sort of bringing it full circle, I think my early education in immigration law as a paralegal was sort of learning how to navigate the bureaucracy in the first instance. And sort of lay that foundation for I've done everything that a person can be expected to do in good faith. And I think that really sort of helps as a litigator to have that instinct to first lay a foundation of your own good faith efforts as a way of getting a court to take seriously your demand for intervention, right?
Well, I want to thank you for joining us today. And we look forward to all of the, are there any new practice guides coming out soon that you can tell us about?
Oh, what's coming out? I don't do the practice guides as much, so I'm just trying to think. There's constantly practice guides coming out, though.
Yeah, it's great. So for anyone out there, cliniclegal.org, right? You can go there. You can donate monthly, right, to help keep things moving. It's funny. So it's a nonprofit organization. So
that's right.
Tax deductible.
That's right.
Right? Unless the law changes and they get rid of that.
And then we would argue retroactivity about.
Exactly. You would have to, right? Well, you would be the one to do it. That's for sure. So please, everyone, check out Clinic, their publications. Are there other publications that Clinic has through ALA or other places?
So in addition to the Representing Clients in Removal Proceedings book, we're lucky enough to have Charles Wheeler, who's the expert on the Child Status Protection Act and affidavits of support, et cetera. And there's some ALA publications along those lines. But we're also, there's an entire section of our website dedicated to our latest resources. And I tell you what, I look at that website pretty frequently, and there's it's a rare week when that entire list of new resources hasn't completely turned over, because we're just constantly trying to help keep folks on the cutting edge of what's happening in the immigration space.
And for an attorney out there who's maybe saying, you know what, I want to be part of this pro bono project. I want to be able to, represent clients in Harlingen, even though I'm up here in Minnesota or wherever. What's the best way for them to get into contact with Clinic?
The BIA Pro Bono Project has a landing page on our website. Just either search for BIA Pro Bono Project or sort of click through the Defending Vulnerable Populations parts of our website. You should be able to get pretty easily in contact with my colleague, Rachel Nagar, who manages that project now.
All right. Well, again, Attorney Jenkins, thank you so much for your time today. I've learned a lot, and I'm sure other people listening are, this has been sort of our push over for the first 10 episodes here is talking about federal court, getting immigration attorneys more confident with the idea of going to federal court. And here, with the work that you've done, we have a prime example of why it's so important. The federal courts, I love the LNB Cuccinelli case, right? They can say, that guy, he was illegally placed. Everything he does is void. Love it. All right. Thanks again. Have a great one.
You too. It's been